everyone, and welcome to Crime in Court. This is the 1996 Menendez brothers trial. We are reading through the transcript. We've streamed through the first trial, and now we are comparing the two and seeing the differences in how the court rules and the differences in how people are testifying. And so far it's been interesting. By the way, we are on week 3, and let me get to my tab. Oh, here. Okay. So today we're on week 3, and why is this page not loading? Let's refresh that page. And in the last stream, we went through Mark Heffernan, the tennis coach, and kind of a friend of the brothers. We went through his testimony. He also went to the police station the next day with the brothers after the homicides of their parents. All right, so today, we are going to read through Amanda Geier, who is the Big Five employee who sold the shotguns to the brothers. And then we're going to read through Valerie Hart, who is a real estate agent. They both testified for the prosecution in trial 1. So let's begin. Please hit that like button before we get started. And I wanted to show you, instead of going over that slide presentation that I put together, showing the attorney's images, I put, whoops, where did I go? Here. That's what I was trying to do. I put all the images of the attorneys on the screen for you so we don't have to keep going back and forth. And I'm actually going to update it. So right now we've got, obviously, Judge Weisberg is right. I'm pointing to him there. It's like opposite on the camera. So you can see he's up at the top, and then down below I've got let's see. Let's go over it once and then no more. So we've got Carol Nahara, Miss Nahara, and behind her is David Kahn. They are with the prosecution. Then we have below Carol, is Terry Towery, and Charles Gessler is behind her. They represent Lyle. Beneath her is Leslie Abramson, and then we have Barry Levin, who I think looks like Richard Gere in this picture. I don't know. It's not a great picture and it's kind of blurry, but he looks like Richard Gere to me. Anyways, so those are the attorneys. And what I'm going to try to remember to do is when people are speaking, I'm going to have them up on the screen. Now, I'm not going to be, you know, going back and forth all the time with it, but whoever's doing the questioning and the cross-examination or the direct, I'll have them up on the screen at that time. Just because we all like visual, and I think it's good to have the visual. So let's get started. We are going to first. There's going to be a little bit of oral argument before we get into our first witness, who is Amanda Geier. So very brief. Okay, so like I said, we've got oral arguments up first, and it's mostly going to be Carol Nahara and Leslie Abramson doing the arguments. The court says, all right, court's in session. The jury is not in the courtroom. He says, the jury is not here. What did you want to talk about? Ms. Abramson says, 2 things, Your Honor. First things first, the people just told us they intend to use the shotgun, the Dr. McCarthy shotgun, with the next witness, Amanda Adams Geier, who was the salesperson at the Big Five. The court says, right. Ms. Abramson says, however, we've never heard anything anything from her about identifying it. There's been no foundation that we're aware of, and the court had indicated we'd had an opportunity to litigate the use of this gun in advance of it coming in, and we thought it was going to come in with Dr. McCarthy. So, of course, we didn't prepare to litigate the showing of this gun today. The court says, well, McCarthy testified to some hearsay conversations he had with people at the firearm company that manufactured the weapon. Ms. Abramson says, correct. The court says, which is hearsay and would not be admissible. Then the people indicated more recently that they had some witness that they're calling, Ms. Abramson said, Mossberg. The court says, from the company itself. Correct, Ms. Abramson says. The court says, what is that all about? Ms. Nahara says, Your Honor, we'll be calling later on, I think either later on this week or next week, Georgia Nichols. She's the representative from Mossberg who can testify as to what exactly this gun is. What is a Mossberg 5406? And this is the only type of Mossberg 5406 that they've ever sold. They ever manufactured, I should say. And basically, this is the one genuine, authentic 5406. The court says, You mean the weapon that's here in court? Yes, says Ms. Nahara. The court says, You're saying you have a witness who will testify that the weapon here in court that was brought in by Dr. McCarthy is substantially similar to the weapon that's reflected in the sales documents identified by Ms. Geier. Ms. Nahara says, not to put too fine a point, Your Honor, but I believe she'll say it's exactly the same. Ms. Abramson says, not the witness today, Your Honor, that is some other witness. Ms. Nahara says, that's Ms. Georgia Nichols. Ms. Abramson says that we've never talked to or had a statement. It's the first we've ever heard who it is. We were told Mossberg rep. The court says, all right, so at this point, have you spoken to this witness? Ms. Nahara says, Ms. Nichols, I haven't, but my investigating officer has, Your Honor. The court says, do you have a report? Ms. Nahara says, no, I do not have a report. Okay, so nothing has been turned over to the defense? Correct, Your Honor. Okay, well, at this point, until there is some resolution of a dispute, are you disputing that this weapon that here in court is substantially similar to the weapon that was reflected in the purchase documents? Ms. Abramson says, I have to dispute it, Your Honor, because I don't know that. I have never seen the weapon reflected in the purchase documents, or I would have turned them over to the court. Ms. Nahara says, Your Honor, Ms. Geier, my understanding, I've spoken to her, she tells me that her exact words were this appeared to be substantially similar to the weapon she sold the defendants, a Mossberg 5406. The court says, okay, she has actually looked at the weapon? Ms. Nahara says, I just showed it to her right now. The court says, and she'll testify that this weapon is substantially similar to the weapon sold to the defendants? Correct, Your Honor. Ms. Amerson says, well, first of all, Your Honor, just to refresh, I realize the witness is in the room, and perhaps it would be best if she waited in the hall and Amanda Geier exited the courtroom. Ms. Abramson said, this is the witness, Your Honor, as the court may recall from the first trial, who initially told Detective Zoller that she had absolutely no recollection whatsoever of this transaction. The court says, I don't want to get into the issue of credibility. Ms. Abramson says, no, just memory. The court says, just what her testimony will be now. Ms. Abramson says, the question is, how can she say that this weapon is substantially similar when she had no recollection of the transaction? Testified in front of the grand jury, again, to no recollection of the transaction. At the trial, testified only with respect to remembering one person asking for certain guns. Now, we're told they showed her in the corner. We weren't part of the conversation about this weapon, and now they're saying in front of her she's going to say it's substantially similar. Right when she's in the room, yes. The court says, let's just have her testify very quickly here and see what her testimony will be, and if she can satisfy me, then she can testify. If not, then she won't testify as far as identifying this weapon, and the people will have to bring in this person from Mossberg. So let's have her come in and we'll hear her testify. Ms. Nahara says, Your Honor, I'm sorry, just so the record is clear. Ms. Geier told me, and Ms. Towery was over here. I should have invited her to join the conversation, but the Mossberg was a Mossberg 5406. Her only confusion was whether the stop was all back or wooden, and she stated that as she looked at it, it appeared to be so. It appeared to be. So her only confusion was there, and she looked at this thing in her hands and she examined it. Ms. Towery was right there. And let's bring her in. Ms. Towery says, um, Ms. Towery says, Ms. Nahara, are you going to use that weapon with the witness? Wait, so Ms. Towery was right there, Your Honor. Ms. Towery, I think this is Ms. Nahara talking. She does this all the time. The court reporter puts the wrong person's name and it gets confusing. I think this is Ms. Nahara talking, saying, Ms. Towery was right there, Your Honor. Ms. Towery said, Ms. Nahara, are you going to use that weapon with the witness? And received no reply. So far, be it from being invited, I was conspicuously ignored. I think, at least I felt that way. The court says, you were somewhere around. That's basically all we know. Let's have her come in. Ms. Nahara says, could we take out the Mossberg? The court says, is someone getting her? Now, Amanda Ann Geier was called as a witness by the people. She was sworn in and testifies as follows. Court clerk made her raise her hand. Okay. Ms. Nahara begins her questioning. Ms. Geier, did you have an opportunity a few minutes ago to view a shotgun? Yes. So remember, the jury's not in yet. So this is all uh, without the jury in the room. And this is like an offer of proof of what she's going to testify to. So um, she says, yes, she's seen it. Ms. Nahara says, and Your Honor, should I mark this at this time or are we just going to identify it as an exhibit? The court says, sure, we can mark it as an exhibit. Ms. Nahara says, thank you, Your Honor. And showing you exhibit 127, would you take a look at that? Mm-hmm. Did you have an opportunity to examine that and hold that shotgun a few minutes ago? Yes, I did. And can you tell me what exhibit 127 is? It's a Mossberg 500 series shotgun. It's an 18.5-inch barrel and a 6-shot capacity. Whatever any of that means, I have no idea. And with regards to the incident that you are here to testify to today, the shotguns that you sold back in 1989, does this appear to be the type of shotgun that you sold on that day? Yeah, the Mossberg was a series called the 500 series, and on all the 500 series are very similar in style. That's a style meaning that they're a pump and they all look very similar. The model number 5406 will indicate any small differences. For example, I cannot remember whether it was wood or the synthetic stock ones that we sold at the time. I would know if I actually pulled one from the catalog to look for sure, but the 5406 will indicate whether it was the wood or the synthetic stock, but they both look similar. They operate the same, it's just the differences in the stock. And did you have an opportunity to look at that particular shotgun and tell me if it looked similar? Yeah, it looked similar. All the 500 series look similar. They operate the same. Can you tell by examining it visually whether or not it operates the same? Yes. Did you examine it visually? Yes. Does it operate the same? Yes. The court says, what is the significance of 5406? The witness says 5406 is the specific model number for each of the guns. The 500 series is the series of guns. It's the style of the gun, meaning it's a pump as opposed to a semi-automatic. It's the type of action. The court says, that's the 500 series you're talking about? Yeah. Are you paying attention, Stanley Weisberg? The witness says, this is the 500 series. The court says, I'm asking what's the significance of 5406. The witness says 5406 will indicate, and I have to look it up, whether it has a longer barrel a shorter barrel, whether it's a wood stock versus synthetic stock, they all have a 5-digit number. The court says, what is the weapon? 127. The witness says, it does not have the model on it, so I couldn't tell you for sure. I just know it's a 500 series. The court says, so it doesn't say on there? The witness says, it doesn't say the 5-digit number on it. Court says, all you can say is that it's a 500 series. Yes. How would you be able to tell if it's the 5406 versus some other model? The witness says, if I had the box that it came in, I would know. The court says, that's the only way of telling. The witness says, and the reps, I'm sure, would have the catalogs and would be able to tell you what the specifics are. So the sales reps would know, but not her. The court says, okay, all right. Anything else? Ms. Nahara says, just briefly. How long had you sold those Mossberg 5406? The 5406, I can't tell you how long exactly Big Five had carried it. We've sold it several years. Have you personally sold it for several years? Yes, I have. And would you say that it would aid you to see what was that? Some kind of a pamphlet or something? Catalog, she said, says the court. The witness says Mossberg catalog or the box that it came, the box, the gun, the box that the gun came in. Oh my God, I can't read already. This is bad. Hold on. I'm trying to get my hair is staticky today. It's like dry and cold and windy, and my hair's just sticking to me, so I might have to just put it up at some point because that's annoying. Sorry. Okay, let me restart that question. The witness says Mossberg catalog or the box that the gun came in would have the model number on the outside. Ms. Nahara says, Your Honor, I believe we have the paperwork, the catalog here in court. It was marked previously as an exhibit. If I can have a moment, I can dig it up. The court says, if there was such an exhibit in the first trial. Ms. Nahara says, I beg your pardon? The court says, if there was such an exhibit in the first trial. Ms. Nahara says, let's see if this helps. Ms. Abramson says, could I ask some questions while counsel is looking for the catalog? The court says, have you finished your examination? Ms. Nahara says, sending the search for the catalog, if I may, Your Honor. The court says, okay. Now we have cross-examination. Again, this is outside the presence of the jury. Ms. Abramson says, do you still work at Big Five? Yes, I do. Do they still sell the 5406? They've changed the models over the years. I don't think they carry the exact 5406 anymore, but I'm not sure. I'm pretty sure they don't. Did you have any reason to believe that the 5406 was a model made just for Big Five by Mossberg? No. Do you remember testifying about a dowel that usually comes in these guns? Yes, I did. Do you know if the gun that the bailiff is holding had a wooden dowel in it? Yeah, they all come with one. Is it in there now? I'd have to take it apart to see. There's a pause in the proceedings. Ms. Aronson says, do you need some help with that? Is it stuck? Ms. Aronson says, I'd like the record to reflect that both the witness and now the bailiff are struggling to get this thing unscrewed. The witness says they're not normally this hard. Ms. Aronson says, I know precisely why I'm making a record of it, Ms. Geier. Interesting. So she knew it was not going to open or unscrew. The witness says, this one is jammed in there. It needs to be cleaned or something. Ms. Abramson says, thank you. We would like to add to our objections the fact that this gun is not operating properly and the witness would not be able to use it to demonstrate a feature of her testimony, specifically the ease with which the wooden dowel that limits the gun to 3 rounds can be removed. The court says, was that part of her offer of her testimony? Ms. Nahara says, no, Your Honor. Ms. Abramson says, it was in her testimony originally and something I'd like to bring out, and this gun obviously is defective in some way. I mean, Deputy Wolf, who's a very strong man, is not unable to screw that dowel. He boasts of his strength, Your Honor, all the time. And I think that's the problem. It just exemplifies one of the problems is in using a different gun than the one that was actually used. The court says, If it's going to be used as a demonstration with this witness, if there is some defect in it, I agree, but just to show a weapon as one that looks like the weapon purchased, I don't see a problem with that. Ms. Abramson says, well, Ms. Nahira says, Your Honor, that's what we would be offering. Ms. Abramson says, good work, Dave. Ms. Nahira says, for the record, Your Honor, we're offering it to show something that looks like substantially similar to the weapon that was sold. The witness says, this one doesn't seem to have the dowel in it. It may have been taken out already. Ms. Abramson says, do you usually have to take this thing off? Yeah, take the barrel off, and sometimes there's a rubber gasket and you have to pull it, or sometimes it dumps out. It's about a 6-inch dowel. I know, I remember. The court says, so what is it? The dowel isn't in there? Ms. Abramson says, right. The court says, so what does that do? What does that do with the people's offer, Ms. Abramson? It's still something you wanted to use for it, or to use it for? Ms. Abrams says, well, I used to use it if we had the right gun and we had the right dowel, and it doesn't. The court says, all right, that still shouldn't stand in the way of the people using the weapon just to show what the weapon looked like. Ms. Nahara says, Your Honor, I'd like to put something on the record here if I may. Ms. Abramson says, one thing though. She just cuts her off. Just to finish the discussion about the dowel and no dowel, since we know this weapon isn't working properly, I would ask the people not be allowed to ask her to demonstrate how to get that off. Ms. Nahara says, I had not intend to, Your Honor. The court says, all right. Mr. Gessler says, that's also a problem, Your Honor. Should this weapon be admitted to the jury, even with the bailiff accompanying it, that they might want to demonstrate or fool around with that, find that that's difficult, and thereby reject that testimony, which would be unfair since we know this is not a similar weapon. The court says, yes, we're not at that stage yet, but certainly if this weapon is some other weapon or some other weapon is received as an exhibit, we'll first have a demonstration as to its workability, and then even with that have some limiting instructions to the jury as to what use they can make of it. But we're at least a week or two away from having it be given to the jury during deliberations, so we can hold off on that one. Mr. Gessler says, I thought that. Ms. Nahara says, a tad optimistic. The court says, had you finished, Ms. Abramson? She says, yes. The court says, people had something else. Ms. Nahara says, yes, thank you, Your Honor. I am holding right now what was previously marked as Exhibit 46 in the previous trial. I don't know if the court wants me to mark it or not. I have used it to refresh this witness's recollection of the stock. Would the court wish for it to be marked or not? The court says, I don't need it to be marked if she's looked at it. All right. Redirect examination. Still no jury at this time. Ms. Nahira says, Ms. Geier, did you have an opportunity to refresh your memory as to what type of stock the 5406 has? It has the synthetic stock. Is that the stock that is on this Mossberg? Yes, it is. Thank you. The court says, so is it your opinion that this weapon in court is substantially similar to the 5406 that's reflected in the other paperwork that you've been showing regarding the transaction you were involved in? Yes. All right, then I'll permit the weapon to be shown with the understanding that it is not to be demonstrated as far as the mechanism that was in dispute here. Ms. Abramson says, well, is it going to be demonstrated as far as any mechanism is concerned? The court says, did you intend to have the weapon used for any purpose in demonstration? Ms. Nahira says, I didn't have her know. No. The court says, okay, if we're going to have any demonstrations, counsel will give notice to the opposition of your intent to do so, and if there's an objection, we can hold a hearing. Okay, why don't you, as soon as the bailiff comes back, we'll have the jury come out and we'll start. Ms. Nahira says, and Your Honor, would this weapon be kept in the custody of the bailiffs at all times as it goes back and forth? The court says it could be given to the witness. All right, we'll have the jury come out. And finally, the jury is back. The court says, all right, the jury is back and we have another witness on the stand. She's been sworn in already. Would you state your name for the record, please? And she does. All right, so the court says, state your name. She does. What did I say? Okay. Direct examination begins. Ms. Nahara is doing the questioning. Mrs. Geier, on August 18th, 1989, were you working at a Big Five sporting goods in the city of San Diego? Yes, I was. And was the address of that Big Five what was that address of the Big Five sporting goods store? 4938 Convoy Street, San Diego. And I have an exhibit that has previously been marked, and I believe it was marked as Exhibit 56. Now showing you what's been marked Exhibit 56. The Big Five store that you were working on, could you give me that address again? 4938 Convoy Street, San Diego. And showing you the exhibit that has been previously marked, will you take a look at where that arrow is and tell me when you talk about San Diego, that's what we're all referring to. Is that correct? Correct. Ms. Nahara says, for the record, Your Honor, I'm putting a little yellow post-it where the arrow is with the address 4938 Convoy. Kept saying convoy, didn't I? Convoy, San Diego. All right, up to August 18th, 1989, how long had you worked at the Big Five sporting good? At that particular location or Big Five in general? At that particular location. 4 years, approximately 4 years. Okay, I'm going to put this on the floor. In calling your attention to Friday, August 18th, 1989, do you recall what time you began work that day? At 12:30 p.m. in the afternoon. And do you recall someone coming into the store between 8 and 8:30 on August 18th? Ms. Abramson says, I'm going to object to leading on time, Your Honor, sustained. Do you recall someone coming into the store in the evening to purchase shotguns? Same objection, Your Honor, overruled. Yes, in the evening. Do you recall approximately what time in the evening someone came in to purchase the shotguns? Anywheres between, it's anywhere, not anywheres, but cool. Anywheres between 8 and 8:30 in the evening. Now going back to Friday, August 18th, between 8 and 8:30, at the Big Five sporting goods store in San Diego, did an individual attract your attention? From what I can recall, there was someone at the gun counter as I came out of the office who wanted to purchase 2 of the Mossberg shotguns. Okay, when you came out of the office, did you go up to the counter? The counter's connected to the office. So as you walk out the office door, you are in the gun department. And was there an individual at the counter? Yes. And can you describe this individual? Was it a man or a woman? It was a male. And do you know if this male was alone or with someone? I do not recall him being with anyone. And when you came out of the office and you were at the you were at the counter and you saw this individual, did you have a conversation with him? What type of conversation? Did you exchange words? Nothing more than, I would like to purchase the 2 of these, and that's not an exact quote. Ms. Abramson says, I'm sorry, I didn't hear the last few words. The witness says that's not an exact quote. Ms. Abramson says, okay. Was that the first thing that was said to you by the person at the counter? Yes, as I recall. Did you say anything first to them? Can I help you with that? Or can I help you with anything? Okay, so you believe you said, can I help you? Is that right? Yes. And then the response was, I'd like to buy 2 of these. Now, when the man said, I would like to buy 2 of those, did he do anything? I believe he pointed to the guns on the rack, to the Mossbergs. Now, this counter that you said that you were at, can you describe what was being sold at the counter? The front of the counter's glass display cases that have various items inside of them. Behind that would be I'd be in between the glass cases and the guns on the display. The guns would be in the back of me on display. So basically, guns on the racks behind her, and then there's a cabinet or a counter, a display counter that has various items, she says. And this individual, when he said, I would like to see 2 of those, what happened when he said that? I can't recall the exact words. I would have clarified which guns he was pointing to and probably would have asked, do you need to see them? Ms. Abramson says, I'm going to object to, probably, Your Honor, speculation on the part of the witness. Sustained. The answer is stricken. The entire answer is stricken. Ms. Nahara says, did you clarify which guns the man wanted? Ms. Abramson says, I'm going to object, Your Honor, unless there's foundation showing the witness remembers. Overruled. You can answer the question. I would have clarified what the person was talking about. I'm going to object as speculation. Sustained. Move to strike the answer. Sustained. The answer is stricken. Thank you, Your Honor. Ms. Nahara says, when you were asked for by this individual that he wanted 2 guns, did he look at several guns? Ms. Abramson says, object, Your Honor, calls for speculation and conclusion. The court says, can you clarify what you mean by look at several guns, please? Ms. Nahara says, when he asked you in front of you, I'd like to purchase 2 guns, did he want to look at other guns besides? As I recall, there were no guns physically shown to the person. Now, when an individual comes in to purchase a shotgun, do they oftentimes like to examine several? Yes. Ms. Abramson says, object, Your Honor, is irrelevant. The court says, overruled. The answer will stand. Ms. Nahara says, did this individual who came in and said they wanted to purchase those shotguns want to examine several shotguns? No, not that I recall. Was this individual just interested in the 2 shotguns that were, or the shotguns that were pointed out? Yes. What's wrong with that? Knowing what you want and buying what you want. That's not an issue. Ms. Abramson says, objection, calls for speculation. The court says sustained. The answer is stricken. Ms. Nahara says, did this individual, after this individual said, I would like to purchase shotguns, what happened? Once I clarified which shotguns we were talking about, then I excused myself to go get 2 of the guns out of the gun locker, which we keep in the back. We don't generally sell the displays unless it's the last ones. Brought the guns up front and proceeded with the paperwork. Okay, when you say you brought the guns up front, what was that, to the counter? Yeah, up behind the gun counter. They're in boxes. So when you brought them up to the gun counter, were they in the box or did you take them out of the box? Generally, I would open the box for the customer to look at the gun and then close it back up. It may stay in the box when they leave the store. And what were these? What was the shotgun that was, or these shotguns that were pointed out by the man that he wanted to buy? It was the Mossberg 5406. And was it 2 separate kinds of shotguns or the same kind of shotgun? The same. So it was 2 of the same kind of shotgun. 2 of the model 5406s. Did he purchase 2 identical shotguns? Yes. Seriously, like, why do we have to ask the same question multiple times? When you came up there with the you came up there with the 5406s, did you have to do some paperwork as part of the transaction? Yes. At that time? Yes. Ms. Nahara says, and Your Honor, I have what has been previously marked as 58. If I may approach the witness, the court says yes. Actually, 2 things I want to do. Now, what was the first thing that you did with regards to the paperwork of this transaction? The first thing I did was ask for a California state ID or driver's license, which is required to buy guns in the state of California at the time. The court says, could you speak up a little bit, get closer to the mic? The witness says, the first thing I did was ask for a California state driver's license card. That was what was required in order to purchase a gun in the state of California at the time. Did the man provide you with a California driver's license or ID card? A California driver's license, yes. So you're presented with a valid California driver's license. Yes. Does it have to be valid? Yes. Does it have to be a California license? Or will any state suffice? No, it has to be California state. Now, after the man gave you the California driver's license, what was the next thing that happened? Then I proceeded to fill out the paperwork. Generally, I start with the top, asking for a phone number, filling in some. Before we get to that, when you say you fill out the paperwork, what specifically do you fill out? It's the Federal Firearms Transaction Form. It's called the 4473. Ms. Nahara says, okay. And Your Honor, I have an exhibit in my hand. I do not believe it's been, no, I'd like it marked next in order, which is, court says 128. Was this an exhibit in the first trial? Ms. Nahara says, yes, it is, Your Honor. This would be previous number 52. And showing you what has been marked 128, I'm going to ask you to look at it. And if you need to take it out of the plastic to look at it, feel free to do so. Do you recognize what 128 is? Yes. And what is it? This is a federal firearms transaction form. And is 128 a copy of it blown up as Exhibit 58? Yes, it is. And is that what and and is that what is to your right, to the right of you? Yes, it is. Now, with regards to that, what do you do when you fill out that form? Once we've obtained the license, at that time we fill out the form starting at the top, and you can't quite see this. We fill out the phone number given to us. Why don't you give me the poker here and I'll move over? All right, coming up to the information at the top. Okay, but prior to that, the part that is not quite legible on the blow up is we start with the purchaser's phone number. I would ask them what their phone number is, and they would give that to me, and then I would write it down. Showing you what's been marked 128, does that appear to have that information on there? Yes. Is that the phone number that was given to you? Yes. Court says, for the record, that 128 was part of an exhibit that you've already been referring to in this trial as Exhibit 57. 57 was an envelope with various records testified to by Detective Zoller. Ms. Nahara says, thank you, Your Honor. We would, if we can, for the record, remove. The court says, so 128 is then the marking of the exhibit is vacated. That's part of Exhibit 57. Ms. Nahara says, thank you, Your Honor. Ms. Abramson says, is there going to be any sub-numbering? The court says, if we do, we'll refer to them, but right now it's been identified as the Federal Gun Record Federal Form. Ms. Nahara says, and once again, the information that you've testified to that was the phone number written at the very top is in fact is that present on Exhibit 57. Is that correct? Yes. Now, after you get that information, what other information do you get? The next set of numbers that you can't really read on the top there is the price that the guns were sold for. Okay, and would that be this information that, for the record, I'm pointing to at the top of the blow up? So that he's referring to a display, a visual aid, and it's like a blow up of this particular document. And she says, yes, it is. And what is that information? It's 2 times $199.99 because there were 2 guns purchased at the price at that price on that form. Okay, and then was there other information as well? Further on down, you also can't read it there, or you can't read it on there. For the record, this would be on the top of exhibit number 58 to the left of it. Those are the corresponding pages and line numbers for the logbook, which the guns get logged out as if they leave the store. We'll get to the logbook in a minute, but just going with the information on the firearms transaction, calling your attention to the information right below at the what's marked as line 1. What is this information here? What is the information of the person purchasing the gun? or that is the, sorry, that is, I thought she was asking, like, what? Sorry, no, she says that is the information of the person purchasing the gun. And the person who was purchasing the gun, did they give you the driver's license in the name of Donovan Ray Goodrow? We recognize that name. All of us who have watched Trial 1 recognize that name. Yes, they did. And there is other information on here as well, marking height, weight, and race, as well as birth date. Yes. And place of birth. Yes. Where did that information come from? The height, weight, and race and date of birth came off the driver's license. The place of birth is given verbally by the customer. Did you get the information off the driver's license that was presented by the man who wanted the shotguns? Yes, everything except the address. Was there something about the address that was different? Yeah, the address was not current on the driver's license. I asked the customer if it was a current address, and he said no, and he proceeded to give me that address. Ms. Abrams says, I'm sorry, Your Honor. The witness says, sorry, I have a cold. The court says, please give that answer again. She says, on the license, I asked the customer if the address is current, and if they tell me no, then they proceed to give me their current address. Ms. Nahara says, is that what happened in this case? Yes. And the address that you were given by the man who came in to buy the shotguns was 63 August Street? Yes. Now, there is some information that is highlighted here on the big chart. Can you tell me why this information is highlighted? It's highlighted because that is the information that was physically filled out by the person purchasing the gun. And the person who came in to purchase the gun, did they sign the signature of Donovan Goodrow? Yes. And did they date it, or did you date it? I dated it. Was this on August 18th, 1989? But didn't we establish this already? She says yes. Now, there is some further information down here. I'm pointing to the lower portion of Exhibit 58, and specifically the portion marked 1 and 2. Can you tell me what that information is? That identifies the guns that were purchased, the type of gun, the model of the gun, the caliber of the gun, the serial number of the gun, and the maker of the gun. And in this case, the two identical guns that you sold, were they the Mossberg model number 5406? Yes. And then, did you sign this information down here where it said 18? Yes. Okay, now, was there anything else that you had to do with this federal firearms transaction record? No. In terms of filling out the paperwork? No, not with the form. And does the document have a backside to it? Yes. For the record, I am flipping over the first page of Exhibit 58 and showing you what is the next page of 58. Will you take a look at that and tell me if you recognize it? Yes. And what is that? That's the back of the Federal Firearms Transaction Form. And showing you what's been marked previously as People's 506, would you take a look at that and tell me if that page is what is represented in the back page of 58? Yes. Now, there is connected to this what appears to be some numbers. Can you tell me what that is? And they appear to be in the right of the document. Those are the two register receipts for the purchases of the two guns named on the front of the form. Court says, okay, again, your voice is trailing off. Witness says, sorry. Those are the two receipts for the purchases of the two guns on the front of the form. Ms. Nahara says, and are there two receipts that are part of the exhibit before you? Yes. Okay, so the two receipts represent the sale of the two shotguns. Yes. And did each shotgun sell for $199? Yes, plus tax. Now, after you filled out all of the information on the federal firearms transaction records, what was the next thing that you do with the course of selling these guns? Once the form is completely filled out, they are sent to the front register to pay for the guns. Okay, and is that what happened here? Yes. And what happens after you sent the man to the front register to pay for the guns? Once the guns are paid for, they come back to the gun counter to sign out for the guns as while leaving the store. And with regards to the receipts, are they placed on there? Yes. After they are paid for? Yes. Does the receipt, that receipt being Exhibit 57, the federal transaction record, the receipts that are connected to it, were those receipts connected to that record when it was taken up to be paid for? I don't recall at what point they were connected to it, either prior to or they're not connected as it was taken up to the register because the receipts came out of the register. It was connected after they were paid for. Do you know who connects them to the transaction record? Could have been me, could have been the cashier, could have been anybody. Did the man who wanted the shotguns come back with the receipt showing that he paid and his document, his firearms transaction? I don't recall whether at that time, whether the form went up to the cashier or if a separate form went up to the cashier, and then the receipts were brought back to the gun counter I don't recall exactly which order it went. So before she was like so gung ho sure about how it worked, and now she's like, I don't remember. So which is it? And this is just on direct. We're not even on cross yet. And she's already like backtracking on some of her answers. And when the man went up to pay for the guns, after he did that, he brought he brought the receipts back to you? Not to me specifically. I was not the person who signed out the guns. So were the receipts brought back to the back of the counter? Miss Abramson says, "Objection, Your Honor. She obviously has no personal knowledge. Sustained." Now, after the guns are paid for, yes. If the guns are paid for, are they brought back to the counter? Miss Abramson says, "Objection, Your Honor. It's irrelevant what happens if." Ms. Nahara says, "It's foundational." The court says, "Why don't you rephrase the question?" Ms. Nahara says, "What happens in a transaction once the guns are paid for?" Okay, the guns never leave the gun counter until they are paid for. They stay behind the gun counter where the forms are filled out. The customer goes to the front, pays for the guns. Once the guns have been paid for, then they will fill out a log stating that they are not stating, but signing that they are taking the guns from the store. And at that point, the guns are given to the customer to leave the store. Now, calling your attention to, you say after they come back, they have to fill out a log. Is that right? Yes. What is this log? It's a federal firearms log. We use it whenever guns come into the store, either from our warehouse or being transferred, we log them in there to keep track of them on a monthly basis. When they leave the store, either being sold or transferred, we log them back out so they're no longer in our store. Does each gun, even if it's identical to another, have its own log entry? Yes, because all the serial numbers are different on each gun. And if I may, showing you two documents from Exhibit 57. Will you look at those documents and tell me what they are? These are partial pages of those logs from when the guns were signed out. Ms. Abramson says, "I'm going to object, Your Honor, as no personal knowledge of this witness as to the guns being signed out." The court says, "Well, the portion of the answer that refers to these as the logs, that portion will remain. The balance of it, as far as the particular weapons being signed out, is stricken as a conclusion." Ms. Nahara continues, "When you say that these are logs, what are the logs from?" They are logs they coincide with the pages and line numbers on the 4473 form that corresponds with the guns that were sold on that 4473 form. And the two guns that you pulled out of stock to sell to the man who came in asking for shotguns, would they be registered on this log that you're testifying about? They would be registered on the other half of the page as far as the specific gun. It's a two-page thing with the gun and the serial number, and then next to it a blank area for the person to sign out or write in whether it was transferred. And do you recognize the documents before you as coming from the log in the Big Five store that you worked at? Yes. And specifically, calling your attention to a line of each one of these documents, does there appear to be the signature of Donovan Goodrow? Ms. Abramson says, objection, Your Honor, calls for speculation. The court says, overruled, and the witness says yes. How can you allow her to testify that it is Donovan Goodrow when you don't know Donovan's signature? You probably can't read it very well. If it's even legible, but she can testify to it. She's an expert in Donovan Goodrow's signature, I guess. Ms. Abrams says, I'm going to object, Your Honor. This calls for speculation since she didn't see who signed it. The court says, objection to the question is calling for conclusion. And the court's, Ms. Nahira says, for the shotguns to leave your store, would they have to be signed for? Yes. And the 2 documents that you see before you, are they from the log of your Big 5 store? Yes. And is there a signature there of an individual stating Donovan Goodrow? Yes. And this would be, who would these, as your knowledge of the logs from your store, be? What would these 2 Donovan Goodrow signatures correspond with? Ms. Abramson says, well, Your Honor, I'm going to object to that. It calls for conclusion. The court says, are you asking in the ordinary course of business what signatures such as that would represent? Ms. Nahira says, yes. The witness says, when we fill out the 4473 form, I have to verify in the logs that the pages and line numbers that I'm writing down on the 4473 form correspond with the pages, lines, and serial numbers on the logbook to make sure I'm getting the correct log line and page and line number. So these pages would correspond with those pages and line numbers. Ms. Nahira says, now the 2 shotguns that you took from stock to sell to the individual who came into the store, you said that was the Mossberg 5406? Correct. Ms. Nahira says, in Your Honor, at this time, I would ask that the bailiff ask for the bailiff's assistance. The court says, all right, we'll have an exhibit 127. Ms. Nahira says, now, Ms. Geier, showing you what the bailiff is holding, exhibit 127, would you examine that and then tell me if you can tell me what that is? That's a Mossberg 500 series shotgun. Now, with regards to the Mossberg 5406 that you sold 2 of on August 18th, would they be substantially similar to this Mossberg that is being held? So the bailiff is holding the box in which the Mossberg gun is being stored for evidence. So they're showing, like they wanted to, they're showing them the actual, it's not the actual gun because the guns were never recovered. So whatever gun they have, it's not the actual gun. So we can't even totally be sure. Is this in fact the Mossberg 500 series? Yes. And in terms of looks, the Mossberg that you sold them, can you describe in terms of this Mossberg whether it looked the same? Yes. And specifically, was the color the same? Yes. Are all Mossberg 5406s identical? Yes. And in terms of the color and in terms of the material, by that I mean the synthetic stock and the metal barrel and all that, is that the way the Mossberg 5406 looked? That sold 2, you sold 2 of them, and the man who came in the store? Yes. Is that the same kind of gun you sold to the man who came in and identified himself as Donovan Goodrow? The same type, yes. And can you tell us how many bullets that gun holds, or how many shotgun shells, I should say, it holds? It holds typically 2 in the receiver and 1 in the chamber. If you have the dowel in place without the dowel, it holds 5 in the receiver and 1 in the chamber, totaling 6. Can you tell the jury what the dowel is? The dowel is approximately a 6 to 7 inch piece of wood, sometimes with a rubber gasket, that goes in the receiver to prevent the person who has the gun from putting more than 2 in the receiver, which is required by Fish and Game laws if you're out in the field hunting. So when you say terms like 2 in the receiver, can you point out that gun, point out on the gun what the receiver is, just point to it. And she does. Indicating for the record, oh boy, what did I just do? Hold on. I don't know what I just did. Sorry. I fixed it. Undo. This is the greatest button. Control Z. I don't know. I screwed up my screen for a second there. Where was I? When you say in terms two in the receiver, can you point out to the point that out on the gun what the receiver is? She does, indicating for the record, Your Honor, what looks like the lower barrel part of the gun. Now, the two shotguns that you sold that day, were they identical to the shotguns that is being held by the deputy? Ms. Abramson says, Your Honor, this has been asked and answered, overruled. As to both of them. Overruled. The witness says, yes. Ms. Nahara says, was each one, and I believe you can sit down now, was each shotgun rung up separately? Yes. And is that common practice or not? Yes. At that time, each gun had to be rung up separately. Why is that? Big Five policy. And in terms of the transaction, the one that you were involved with on August 18th, did the man who came in to buy the two Mossbergs pay cash? Yes. And was this considered a large transaction for the end of the day? Yes. Now, do you know if the individual bought any shotgun shells for it? It's not in my knowledge. Is there anything about the receipt that would help your memory in terms of that? No, it would have been rung up on a separate receipt if it had been purchased. And why is that? The guns are rung up separately and on their own. And any other items, whether it be shoes, shotgun shells, whatever, would be rung up on a completely separate receipt and given to the customer to take. Ms. Nahara says, I believe I have nothing further, Your Honor. If I may have just a moment, I have nothing further at this time. Now we've got cross-examination by Leslie Abramson. Ms. Abramson says, may I approach the witness, Your Honor? With Exhibit 67, the court says yes. Ms. Nahara says, can I refresh my memory, Your Honor? Ms. Abramson says, it's a Fiace dove load, open shell. So whatever it was a shell or a picture of a shotgun shell. All right, cross-examination begins. Showing you Exhibit 67, do you recognize what sort of thing that is? It's a shotgun shell. And do you recognize the brand? No, I don't. Did the Big Five that you worked in 1989 sell Fiocchi, Fiocchi ammunition? No, I believe not. Do you believe that you testified oppositely in the trial the first time? So she said they did have it. Now she's saying they didn't have it. She says, no, I don't. Do you know what dove load is? Yes. What is dove load? Dove load refers to a specific load of powder versus a type and size of the BB that is in it, regularly a 7.5 or an 8. Can you read the shell that's in your hand? Ms. Nahara says, I'd object to anything read from the shell as hearsay. Overruled. The witness says, it's a size 8. Ms. Abramson says, does it say dove or game load on it? It says dove load on it. Are you familiar with when the dove hunting season is? Starts September 1st of every year. And does the Big Five store that you worked in stock game load shotgun ammunition for the opening of the hunting season? Yes, we do. And at that time of year, just before the opening of the hunting season, would there be stocks of that type, whether that brand or not, ammunition in the aisleway of the store? In that particular location, it wasn't in the aisleway, it was up against the office wall. But where customers could take it off by themselves. Yes, yes. And they wouldn't have to ask a salesperson for assistance. No. Is that correct? Yes, that's correct. Now, I understand, Mrs. Geier, that you did not have the person to whom you sold these two guns sign the logbook yourself? No, I don't believe I was at the counter to have him sign it. Cite it. Sign it. Why can't I form words with my mouth sometimes? Sometimes talking is difficult. I believe one of my part-time staff persons was left over there to finish signing out the gun. So it wasn't her who completed the purchase. So then it was fair to say that you don't know if the person you are dealing with is the person who signed the logbook. I guess I couldn't say that for sure. Well, you can't say it at all. You didn't see it. No. And if two people had come in the store, for example, and one of them came to the counter and dealt with you and the other one signed the logbook, you wouldn't know whether that's so or not. I wouldn't have personal knowledge, but the person who is signing out the guns would have knowledge. Well, only if the person who was signing out the guns was, and they would verify the identification, make sure that the same person is signing out the guns who filled out the original form. But you don't know if the person who was accompanying whoever signed the logbook asked for identification. You know that you would have, but you don't know. So, because if Erik had been standing there by himself, she wouldn't necessarily ask identification of Lyle because he wasn't around. But if she knew Lyle was with him and like standing around and they were together, she would have ID'd both of them, I guess, is what she was saying that she would do. I think she testified to that in the first one. I don't know if they would have, she says. You don't know if they would have? They should have, but I don't know if they would have. Okay, and if, for example, one person talked to you and gave you the ID and filled out the federal firearm transaction form with you and walked up to the register and paid the money and then handed the register receipts off to someone else, and that someone else came back and saw your part-time employee and that someone else signed the logbook, you don't have any way to determine whether that happened or not. I don't, but the store's not that large. There's a very small space between the register and the gun department but you didn't even see the person come back. No, not to my knowledge. Now, talking about your knowledge, do you recall when it was that this transaction was first brought to your attention by anyone? March 1990. And in March of 90, who was the person or persons who brought this transaction to your attention? Detective Zoller and his partner. And that's Detective Zoller from the Beverly Hills Police Department? Yes. And on that, do you remember the exact day in March or no? No. Was that one day in March of 1990 that you had this contact with Detective Zoller? Yes. And at the time that you had the contact with Detective Zoller, did you look at the documents that are collectively, that's right, I want to see all right. They're collectively marked right now 57 because they were contained in this envelope. Yes. And did you look at those documents on that day in March when Detective Zoller was there? Yes. And that would include the yellow one in the federal firearms form. Is that correct? Yes, it is. And that's a standard document that gun stores are supplied with. They get from the federal government, correct? Yes. But the other documents, the ones that read in the upper right-hand corner on the one I'm holding in my right hand now, it says page 29. Yes. And on the flip side, it says page 30. Page 30. So page 30. And the second document in the upper right-hand corner, if I hold the holes to the left, says page 36. Correct. And on the other side, it says page 37. Yes. Now, does page 36 read across to page 37? No. Does page 36 refer to the same firearms that are on page 37? No. And the same is true. Does 29 have anything to do with the things listed on 29 have anything to do with the things listed on 30? No. So you saw these documents, looked at these documents on that day in March when Detective Zoller was there? Yes. And isn't it true, Mrs. Geier, that in March of 1990 you had absolutely no recollection of this transaction? Yes. And you told that to Detective Zoller. You remembered zero about it. Yes. 2 years later, did you testify? 2 years and some months later, did you testify before the grand jury? Yes. Concerning this case? Yes. And at that time, you still had no recollection about the time of day or the specifics of a transaction, correct? What was the date of the grand jury trial? On August 10th, 1992. That was when you went downtown LA. Right. I'm not sure that I had any recollection, but it wasn't brought up in the grand jury trial. Well, you recall testifying that you didn't recall whether the individual to who you sold the guns was alone or with someone. Correct. Do you recall you never indicated the time of day in which this occurred? I have indicated the time of day in some testimony, maybe not at the grand jury. Well, you testified in the trial before. Right. Okay, but I realize there's a lot of times. Yeah. Okay, let me help you a little bit here. 2 years ago, in July of 1993, did you testify in this very courtroom with this very judge and these very same defendants? The same defendants, yes. And the same judge. I don't recall for sure if it was the same judge. Okay. I fear to ask, did you remember seeing me then? Yes, I remember seeing you. Okay, but all the other lawyers were different. Yes. And there were two juries. Do you remember that? Yes. There was one here and there. There was one like sitting in the gallery. Right. I'm going to object as irrelevant, says Ms. Nahara. Overruled. Ms. Abramson says, that was the previous trial. Yes. Now, do you remember testifying in front of a larger number of jurors, but without a judge and without any defendants? That was called a grand jury earlier than that, a year before that. There was a judge at the grand jury. Was there? There was someone sitting to my left. I don't know if it was a judge, but someone sitting there running the proceedings. Okay. Were Erik and Lyle Menendez there? No. Okay, so you were being questioned only by the prosecutor, is that correct? Correct. And do you remember the previous two prosecutors on this case, Mrs. Bazanich and Mr. Kuriyama? Yes. They're different than these two people. Yes. Was Mrs. Bazanich and Mr. Kuriyama with you at the grand jury testimony? Yes, they were. And does it sound appropriate that that was on August 10th, 1992, 3 years ago? Yes. All right. Now, would it be accurate to say that sometime after you testified before the grand jury, you told Detective Zoller that you had some memory of the transaction? Yes. The memory came back to you through looking at some schedules that were determining what had been going on that week. That was a very specifically hectic week with some very specific things that had gone on, that some recollections had come back to me referring to the schedules and the staff that was on duty. Really? Is the testimony that you have given here, apart from what you've said about the documents which are right in front of us, the testimony about the person, about the time of day, and about the little bit of conversation you can remember, is that the testimony of a transaction that happened during a very heavy week? It was a very heavy week, yes. And are you assuming that because you've gone back and you've looked at schedules and you've determined that the week that included August 18th was a very heavy week, that that particular transaction must have happened that day? Not because it must have happened that day. It did happen that day due to the dates on the receipts and the forms that are filled out. There's no time on the receipts, is there? No. And the fact that this was a late sale for $400 is what makes it unusual in your mind? Yes. Correct. It stands out. Yes. But you had no memory of it whatsoever when you were first asked about it in March of 1990. When I was first asked about it, I was just shown the form and no other documents going around it, and so I didn't recall specifically that day. But what that form tells you is that two Mossberg 5406s were sold at one time. Yes. So how many times has that happened in your experience? Two of the same guns? Two of the exact same guns. Probably just about never. Right. But seeing that this was a transaction involving two of the exact same guns didn't trigger your memory, correct? No, not of any specific memories at that time, just looking off of the form. So she has no memories of this other than what she's recollected after she read the form. She doesn't remember these people. I mean, these people. I don't. She doesn't remember Erik or Lyle. Like she barely remembers him as, just asking to see the guns and to purchase them. Did you look at the man who you believe you sold the guns to? Yes. Do you have any recollection of how old he was? At the time, no. Now, you've been in this courtroom before. We've established at a time when both Erik and Lyle Menendez have been 20 feet away from you. Yes. And you have never identified either one of them as the people who have bought the gun. No. And you still can't. No. But although the receipt has no time, in fact, none of these documents have any time indicating when it occurred, correct? Correct. You still believe, based on schedules and the fact that you recall a busy day, that this sale happened between 8 and 8:30 p.m. Yes. Are you absolutely certain? I can't be certain of exact time, but that's what I recall, it being after 8 p.m. in the evening that we had such a large transaction towards the end of the night. Sorry about that. I saw it coming. I just couldn't pause at the right time. We had a delivery. You couldn't tell. I think it was just the mailman. So what year was it that you first remembered this unique transaction? I don't recall. 1993? Again, I can't recall. Do you recall at the very first person that you told, the very first person connected with this case was Cindy Erdelay? Was Cindy Erdelay the defense investigator? Yes. And would it refresh your recollection if I told you that the first time that you ever spoke to Ms. Erdelay was, Ms. Nahara says, I'd object to reading anything off the report if she's going to refresh her recollection. The court says, just asking for a date. Is that it? Ms. Abramson says, just asking for a date, Your Honor. Overruled. Ms. Abramson says, was Thursday, May 27th, 1993? It's possible. I don't remember the exact date. Was it just a couple of months before you came and testified at the trial in this courtroom where you did see Erik and Lyle Menendez? Yes. Ms. Abramson says, I'm going to show you two photographs that have been marked previously. The first one, Your Honor, was marked previously as 144. Can that now be 128? The court says yes. Ms. Abramson says, and the second one was previously marked 145. Can that be 29? The court says 129. Thank you, Your Honor. I don't know if you're going to be able to tell much from 128, but why don't you look at that for a minute, especially if you also look at 129. Anything in those two photographs? That was the store that I worked in at that time. And can you tell us with respect, I want to put these up on the board even though they're teensy, but can you tell us with respect to 128, what is the object that is most observable in that photograph? The security cameras above the office. And if the security cameras are above the office, are they also adjacent to the gun rack? Yes. And are they aimed in a direction to appear to observe gun transactions? One to the gun transactions and one towards the register area. And are those real security cameras or are they fake security cameras? They're fake security cameras. That came in the first trial, but I just think it's important enough to take note of. Again, they're fake security cameras. But you don't tell the customers that? No, we don't. Why doesn't Big Five have big real cameras? They do. They don't use them in every single store. They use them in select stores. They use them in select stores depending on the problems in that area. The crime problems? Yes. So theft and robbery problems? Yes. Okay, but they have cameras that look real in every store? Yes. And these cameras are made to look real? Yes. Now, I don't have a grease pencil, but on 128, one camera is pointing at the camera taking the picture, and the other camera is pointing to the left of the photograph, correct? Correct. And is the one pointing to the left of the photograph the one that would be pointing down towards the gun counter? Correct. And these are mounted up near the ceiling, aren't they? Yeah, the office doesn't go to the ceiling. It's not an enclosed office, but it's up towards the ceiling. So in this photograph, 129, is the office the area that one can see a white wall with like a window? Yes. And right next to that office, is that the gun rack that you were talking about? Yes. And I take it from what I can see in this photograph, the Big Five sold a wide variety of guns. Yes. I see in that rack what appears to be shotguns, rifles and shotguns. So rifles and shotguns, and I see little white things on the guns. Are those price tags? Yes. And do you know when these two photographs were taken or by whom? No, I do not. In March of 1990, when Detective Zoller was there, was he taking any pictures or was anyone with him taking pictures? I don't recall if they were taking pictures. Do you recall at any time whether a photographer from the Beverly Hills Police Department came down to take pictures? I don't recall. No. Were all the rifles and shotguns that were at that gun counter priced the same or did they have different prices? They all have different prices. So what's the cheapest one you had at that time? Do you remember? I don't remember. Is $199.99 an expensive shotgun? No. Is it one of the cheaper ones that you carry? It's one of the lesser expensive. Yes, not the least expensive, but one of the lesser. Is the least expensive also a Mossberg or was it a different brand? Back at that time, I couldn't tell you exactly. I don't recall. Now, you said you saw the man standing at the gun counter when you came out of the office? Yes. How long had you been in the office? I don't recall. What were you doing in the office? Probably doing some paperwork or getting something out of the office, but I don't know for sure. Okay, please don't tell us probably. Sorry. You worked there every day, right? Yes. You could have done a zillion things? Exactly. I don't want to know generally. I want to know if you remember. I don't remember. You don't remember what you were in there for, and you don't remember how long you were in there, correct? No. And you don't remember the transaction, whatever transaction you may have been engaged in before this one? No. Do you remember how long before this one it was? No. Do you have so you have no way of determining how long the man had been standing at the counter before you saw him? No, I can't give you an exact time. And you have no idea whether or not that he was examining visually the guns and the price tag for the for the period of time before you ever came out. So you don't know if he was checking out prices and price tags and whatnot before he came out. Looking at them, you can't touch them or anything. There's a counter in between. There's quite a distance. But you can look at them. Yeah. And you can read the price tags. That's why they're there, right? Yes. And you don't know if there was another person with him also looking at the price tags or looking at the guns before they came in. Or before you came out, sorry. No, I can see through the windows. I don't recall anybody else being at the counter besides one person at the time I stepped out, but prior to that, no. Can you see in these photographs? You know what, Your Honor, if I can have a moment, I have more photographs of this location in the locker. Court says, how much longer do you think this witness's testimony will be? Ms. Abramson says, not much longer, and she probably wants, the court says, just how much is not much. Let me give you a real estimate, just a few minutes, Your Honor, 5 minutes. The court says, okay, any questions by you, Mr. Gessler? Mr. Gessler says, probably not if Ms. Abramson covers the area that I still intend to. The court says, okay, any redirect at this point? Ms. Nahara says, maybe a minute or two, Your Honor. The court says, okay, all right. Ms. Abramson says, it's going to take me a minute longer, Your Honor, because they're the only copies of those photos I believe are in possibly in the clerk's possession, so let me just move on. I don't know if it's important enough to take the time. Ms. Geier, can you show us in the smaller photograph I've put up here, 129, does it show the area where you say ammunition for the game season and the shooting season was stacked? It was stacked. There's some stacked here, and the majority is stacked in front of the office across here. When you say some stacked here, you pointed to an area on the photograph where there appears to be white boxes. I'm sorry, that's not ammo. That's target shooters. It's all stacked here. You understand this picture was not taken on August the 18th, 1989? Right. Whoever bought the gun didn't take a photograph. Right, but that's generally, when I worked in this store, that's where we stacked our ammo every year, was underneath the office window here across the. So it's the right-hand side of the photograph, and under the window, there's some storage space up against the wall there. Right, just in front of the office, behind whatever this, there must have been the court says, all right, now you're really whispering here. Ms. Abramson says, you say there appears in this photograph here to be what appears to be a tent that is erected in front of the office wall. Yeah, but we don't know when this was taken. I don't know when this picture was taken, no. Just before the start of the hunting season, however, in this store, you stack ammunition in that area where the green thing appears. Well, yeah, the green thing is probably set up from the office. It just happens to be blocking the view of the office. But as you can see, they're starting to have some boxes stacked there, and they went all the way across. So you say they're starting. Are you talking about the mustard colored boxes? Yes, those are some shotgun shells right there, and they continued over towards the front window. Okay, so there's a mustard colored box in this photograph next to the green thing, and that's shotgun ammunition. Yes. And as of August 18th, that's close enough to the start of the game hunting season that the ammunition would have been stacked at that time, correct? Yes. And if someone had picked up a box of, say, dove load ammunition and gone to the register to pay for it, there's no forms that have to be written for that, are there? No. At least there weren't then. Not then. There aren't now, as far as you know, either. There aren't now either. Have you ever demonstrated for a customer who purchased a Mossberg 500 series shotgun how to remove the wooden dowel? Yes, I have. Have you ever removed the dowel yourself? Yes, I have one at home myself. Apart from your own, have you ever removed one for a customer? Yes. It is not illegal to take the dowel out, is it? No. It's only illegal if you're hunting out in the field. So, have you frequently removed the dowels for customers? No. Do all the shotguns come with these dowels? Yes. And some are dowels, some are plastic pieces, depends on the gun. So several different guns, though, come with wooden dowels. Yeah, all the shotguns come with some sort of it's called a plug. They're required to have them because the guns are generally used for hunting. And if the gun is going to be used for hunting, the game law says that people can't have more than 3 rounds in them at a time. Yes. But if people are buying the guns for self-protection, there's no law that says they can't take out the dowel. Correct. If you take out the dowel, you can load 5 shells in the gun just by putting them in sequentially through the loading. 5 in the receiver and 1 in the chamber. Okay, I want to get to how it gets you just pump. You just put 5 shells in one right after another. There's like a little spring loading device that the shell goes in. Yes. You can put 5 in. Yes. If you do nothing else, that's it. You've hit the capacity if you do nothing else. If you do nothing else, you've hit the capacity of the receiver. So if you want to add a 6th round, you have to pump the gun so that one of the shell goes up into the firing chamber. Not necessarily. If the action is open when you put the 5 in the receiver, then you just have to stick the 6th shell straight into the chamber and close the gun and it's ready to fire. So you can do that if you say the action, there's like a movable part that lets you see inside. Yes. And that's open. If that's open, then you can just put 6 in without having to pump. Yes. So it's really quite easy to do. Yes. And ordinarily, is it quite easy to remove the wooden dowel as well? Yes. You said these guns come in boxes, cardboard boxes? Yes. Do the boxes have illustrations or directions concerning the dowel on them? Yes, they come with the owner's manual giving instructions on how to use the gun and cleaning it and so on. So, from the owner's manual, one could determine how to load it and how to remove the dowel. Yes. And it also tells you how to maintain it and clean it and store it. Yes. Does it also have all kinds of warnings? Be safe? Yes. What kinds of ammunition it could take? Yes. I have nothing further. Thank you. Mr. Gessler has no questions, so we're going to do a brief redirect with Ms. Nahara. Now, in response to Ms. Abramson's questions about if someone or two people were at the gun counter looking at the guns and the prices, my question to you is how far would they be from the guns, the shotguns? 3 feet, 4 feet? And how much of the gun would be visible to the hypothetical person? Virtually all of the gun. Okay, would they be able to see all sides of the gun or just part? The side facing them, they would see the backside. So they would not be able to see the entire, no, three-dimensional gun. No. Could they examine the gun from this location? No, not unless there's a salesperson there to hand them the gun. And standing on the other side of the chamber, she might counter, if they weren't handed the gun, then they couldn't work the chamber. They couldn't check the size. They couldn't do any of that. No, they're not that close to it, and the guns are locked. And when people usually or typically spend close to $200 on shotguns, do they typically like to do these things? I'm going to object to what people typically like, Your Honor. Sustained. The individual who came into your store to purchase these two shotguns, do you recall if he wanted to check the chambers, check the sides, work the chamber, do any of that? I don't recall them wanting to handle the display at all. Ms. Abramson says, never mind, I'm withdrawing the objection. Ms. Nahir says, did the individual who you sold the guns to, do you recall if they asked you how it worked or anything along those lines? Ms. Abramson says, Your Honor, it's creating confusion for counsel to use both the individual and they in the same sentence. The court says, yes. Ms. Nahir says, I'm sorry, I didn't realize I did that, Your Honor. Court says, more than one person. Ms. Nahir says, the question being, did the individual ask to see how it worked? Not to my knowledge. Now, with regards to what you recall and don't recall of this event, is it fair to say that there is no doubt, based on all the documentation before you, that on August 18th, 1989, an individual came in, purchased two Mossberg shotguns, and identified himself to you as Donovan J. Goudreau? No, there's no doubt in my mind. And the guns that were purchased was the gun that was similar to the type that you identified here in court. Is that correct? Yes. Thank you. Nothing further. Ms. Abramson says, in 1989, Mrs. Geier, did the Big Five store carry more than one brand of shotgun shells? Yes. Ms. Nahir says, I'm going to object. Outside the scope of redirect, the court says it is. Do you have more on this? Any more questions? Ms. Abramson says, I don't believe so, Your Honor. The court says, I'm sorry. She says, I don't believe so. The court says, okay, thank you. You may step down. The witness says, thank you. And then the court says, we will be in recess until tomorrow at 8:30. Again, we'll be breaking around noon time, and you won't be here in the afternoon to accommodate an appointment tomorrow. So they're having a half day. Following day. He says, don't discuss the matter, don't form any final opinion. We'll see you back here tomorrow morning. All right, so jury leaves. Court says, this is held outside the presence of the jury. Court says, who is your witness tomorrow morning? Ms. Nahira says, Your Honor, that's what we're going to determine. We have a witness still here who may need to be ordered back tomorrow, depending on the court says, all right, depending on what we do here. The court says, who is it that you want ordered back? Ms. Nahara says, Your Honor, her name is Valerie Hart, who we will hear from shortly. But she doesn't testify then until the next day. So this is the 24th of October, 95. She doesn't testify until October 25th of 1995. All right, so why don't we order her back for tomorrow? And depending on if something changes, I'll call you. Would that be okay? The court says, okay. Ms. Hart, you're ordered to return at 8:30 tomorrow. Ms. Abramson says, Your Honor, we have some matters we still need to litigate. The court says, yes, what's that? I was just handed for the first time diagrams, copies, what I take it are blow-up diagrams that Mr. Khan indicated he intends to use with Dr. Lawrence on Thursday. We are objecting to the use of Dr. Lawrence in their case in chief because we first received a report concerning Dr. Lawrence yesterday, and we're in this courtroom 5 days a week, have not been able to talk to our experts, haven't even been able to get Dr. Lawrence's report to them in time to discuss it. These charts, before we sign off on them, would have to be shown to our experts and the coroner, particularly, to see if there's anything even approximating accurate. I have questions about them just looking at them right now, and I'm just tired of having this kind of evidence, especially scientific evidence, dropped on us at the last minute. If you've been following along with me on this, you will realize that this is the state's MO. They basically surprise them with evidence and witnesses the day of without warning. So they keep doing this. And we're told, get ready when we have had 2 years to put this case together and at least a year of working with Dr. McCarthy to come up with their theory. The court says, what are you asking at this point? Ms. Abramson says, I'm asking this court at this point to inform the people that they cannot put Dr. Lawrence and these charts on until the defense has had adequate time to prepare to deal and with respect to Dr. Lawrence, particularly, Your Honor, since they have known for some time that they were going to put on a theory that was in contravention to Dr. Golden's findings, that they not be able to use Dr. Lawrence, who they drop on us in the middle of a trial at all because much of our preparation has been going on for weeks. The court says, let me stop on this. The only reason you're bringing this up now is because some exhibit was shown to you, and the witness is not testifying tomorrow, so we'll deal with it tomorrow morning. Ms. Abramson says, all right, that's fine, Your Honor. I should tell the court that we intended to renew the Dr. Lawrence thing today when we had a chance. So maybe they had a motion already to exclude his testimony, so maybe they're renewing their motion to exclude him, perhaps. And Mr. Khan says, Your Honor, if I can only say at this time, Bailiff Spiegel says, Your Honor, the jurors. The court says, let's let the jurors go. Ms. Abramson says, it's really not fair to the people, Your Honor. The court says, okay, Mr. Khan. He says, yes. The court says, again, this is something we can do tomorrow. This all arose by reason of a discussion last Friday to which the subject was brought up in regard to the people indicating they have a new witness they wanted to call and a discussion regarding the defense response to that. And on Friday, I ordered that the prosecution provide to the defense by 9 a.m. Monday, which was yesterday, a report of proposed testimony of this new witness. And if that report was not received by the defense by Monday, yesterday, that witness was not going to be permitted to testify. And that's the last I heard of it. I haven't heard anything else. Ms. Abramson says, we got a report yesterday. We had 10 minutes to look at it. I looked at it again briefly last night. I sent it out to my experts today. It certainly raises significant issues. If we had had that report before Dr. McCarthy testified, it might have shaped that examination at that hearing and perhaps decisions about that hearing. But it is significant. It raises significant issues that have to be dealt with, and I need the input from the experts before I can adequately cross-examine Dr. Lawrence. I also want to take Dr. Lawrence's report to Dr. Golden and see what he has to say about it. And of course, we can't talk to anybody while we're here. And the court says, there's no doubt that you should have ample opportunity. And Ms. Amerson says, thank you, Judge. The court says to prepare. And if there's some substantive objections to his testimony or procedural objections, you should be heard on those. It's a question of when. And since this is the first I've heard of it since last Friday, I don't know why right now is any better than tomorrow morning. And Ms. Amerson says, it isn't. And the court says, Mr. Gessler, he says, let's put his image up because he's doing some arguing. So there we go. All right, Mr. Gessler for Lyle says, it might not be, Your Honor, but I think we were just notified that they intend to call the doctor on Thursday. Court says, okay, well, if you, Mr. Gessler says, additionally, the court says, from what you're telling me, it would seem that you have a legitimate objection to that witness being called this week because you haven't had time to prepare. Mr. Gessler says yes. The court says that's the one objection that you have, and I agree with you that you need some time to prepare. Mr. Gessler says, one further brief ground for the objection, Your Honor. The report, as I recall, I don't have it with me right now, is either 2 pages or 2.5 pages. If it is not nearly as detailed as the autopsy report of Dr. Golden or that we're used to dealing with from pathologists, and therefore, because it does not have the detail, it requires further preparation on our part, not less preparation, in order to rebut the one-sentence conclusions that are sometimes found as to the time wounds were inflicted or the angle of the wounds or other very important aspects to the case. The court says, okay, I understand that, and as far as the time frame for preparation and that sort of thing, we can discuss that further. This all has arisen before because this all has arisen because the people have elected to call this witness, and that decision was only made last week. Mr. Khan says, yes, Your Honor. As it was only last week that we determined, I'm going to put Mr. Khan up too, because he's the one doing the arguing. So let me switch. It's going to get confusing. I'm going to forget, but I'm going to try my best so you guys can see who's arguing. Mr. Khan says, yes, Your Honor. As it was only last week that we determined that this witness is available to be a witness for us, or as soon as we found out that this witness was available to be a witness for us, we provided counsel with that information immediately after we learned it. But I wanted to put on the record that last week, it was early in the week when we informed counsel of that he would be a witness in this case. It was on Friday when he indicated that we intended to call him this Thursday. So we put that on the record last week too. The reason I'm telling counsel about this now is because I wanted to remind counsel that, as we said last Friday, that we wanted to call him this Thursday. My God, this is so confusing. That is still our intention. As it turned out, the witnesses that we called this week have been taking up more time than we anticipated, and I don't want to mislead counsel into thinking that we're going to go ahead with every witness that we indicated prior to calling them, because it has been our intention all along to call him on Thursday. That's what we indicated last Friday. And we just checked with his schedule. He has put aside Thursday for us, and so he feels very strongly that it has to be Thursday. So I just wanted to put counsel on notice that we do intend to put him on notice to call him on Thursday. The court says the defense has a right to prepare for his witness testimony. It's not their fault that you waited until last week to decide to call a witness. Thank goodness you're finally yelling at the prosecution. This is what we need, more judges to hold the prosecutor's feet to the fire, not just the defense. He says trust me though, I'm not giving Judge Weisberg too much credit because he's still biased. But in this regard, in arguments and stuff for not as important things, he will be better. I don't know what I'm saying. He does seem to have a soft spot, or maybe it's a pet peeve that I should say, maybe, that he doesn't like it when the prosecution tries to pull the wool over the defense's eyes with, oh, these are going to be our witnesses today, and then you throw in a different witness that they weren't prepared for with exhibits that they didn't know that they were going to have. So he does not seem to be very he doesn't seem to like that a lot. And I think either side who did it would get a tongue lashing from him. The defense has a right to prepare for the witness testimony. It's not their fault that you waited until last week to decide to call a witness who apparently will be impeaching to some extent of Dr. Golden, and they certainly have a right to prepare for that. And you can't force the issue by scheduling the witness and saying he wants to testify and therefore it's got to be now, whether or not the defense is ready for it. This is not some witness they had months to prepare for. It's some witness that just materialized last week. So it's really not fair. So they legitimately have a right to prepare. So if they're not ready on Thursday, whether that witness wants to testify or not, or whether you want to call him or not, it doesn't determine that he's going to testify. At this point, from what I heard, he won't be testifying Thursday. Mr. Khan says, so is the court ruling that he can't testify on Thursday? Court says, from what I heard so far from the defense being presented with the materials Monday, I think they have a legitimate right in preparing for this, and they have not been given sufficient time to prepare. So just because the witness wants to come in on Thursday or there's been some schedules arranged for that purpose, the control how this trial will proceed with the order of proof if a witness of this magnitude arises at the last minute and there's reason to give the opposition time to respond to it. Ms. Abramson says, the other thing, Your Honor, is I will be objecting to the charts. The court says I don't want to go into the specifics of the witness's testimony now. Ms. Abramson says, I don't know where these charts are coming from, whether they are coming from that witness. They are coming from Decision Quest, and Decision Quest is here, and the witness is up in Stockton where he works. But I would indicate that, particularly with something like this, given the issues in this case, we have to have a hearing as to the accuracy before a chart like this, that purports to be a medical chart is viewed. To cut to the chase to what is coming up tomorrow, I have been shown the so-called escape plans as the prosecution thinks they are going to get them into evidence here. Ms. Nahara says, Your Honor, that is not appropriate. I have spoken with Ms. Towery and we have more work to do on that. The court says just talk to the prosecution. Ms. Towery says, Your Honor, I did talk with Ms. Nahara. Ms. Nahara says, I recognize that there is more that needs to be done, okay? Ms. Towery says, there was an issue we did not resolve. One issue we did resolve with respect to what have been referred to as the so-called escape plans in the court, and Ms. Nahara and I discussed whether or not the prosecution would be going into the reason for the search of both Erik and Lyle Menendez's cells, which was the chain on Lyle Menendez, which at one time was believed to have been tampered with, which it subsequently turned out it was not. She indicates that the prosecution will not go into that area. However, we did have a disagreement in terms of the prosecution's abilities to have the deputies read from the so-called escape plans, and I do want to object to that. I don't know whether the court wants to take that up today or tomorrow, but I would like to be heard on that, particularly since there has been a dispute all along as to what these documents are. The documents do speak for themselves. They are the best evidence of what they are, and to permit the deputies to read from them and take pieces of them and color the implication of the document before the jury, I would object to the court permitting that both as improper opinion, speculation on the part of the deputy, and precluded under 352 as more prejudicial than probative. So again, I don't object to the general description of documents obtained from the cell, but to have the deputies go through and read a particular portion of the document in the prosecution's direct examination, I would object to. The court says, all right, well, I'll take that up by way of questions and answers. I don't see a reason to rule on that now. Anything else that has to be resolved before we start tomorrow? Ms. Abramson says, well, I will, tomorrow morning, I need water. Hold on one second. Ms. Abramson says, well, I will tomorrow morning, I assume, be given a new version of the redacted plans and hopefully early enough in the morning that I can let the court know before 9 o'clock whether we need a hearing or not. The court says, okay, and if we have extra time and if Detective Zoller is here, perhaps we can do that hearing involving Ms. Maher as well. Ms. Abramson says, very well, Your Honor. Mr. Khan says, in regard to the illustrations we have provided to counsel, I would ask that we take that up tomorrow so we can finalize and prepare for the jury. Once again, that is simply an illustration. It is a color drawing. That's all it is. Who's talking here? Mr. Khan, sorry. There is no reason why counsel would have to refer their experts to that illustration. Ms. Abramson says because it could be misleading. Mr. Khan says it was made from the drawings, from the photos. An illustrator looked at the photographs and indicated on a human body where those photographs on or where the wounds are depicted on the body. The court says it's not a big deal. All you have to do is have it faxed to whoever it is to look at them. Regardless, it doesn't require us continuing at this point, but I do agree that there should be some time to prepare by the defense. But at the same time, I want to get the evidence, if it's going to be admitted, presented so that we don't have any lapses in the testimony. Ms. Abramson says, just so that the court understands, because our days now that we are in trial are taken up with being in trial, and because it's very difficult to reach people after hours, it's our position that the people should have abided by the 30-day rule and provided us with the names of their witnesses in their case in chief 30 days before trial. The court says there's not a rule that binds them to only those witnesses, and if they come up with a new witness that they didn't know about, just the same as if the defense had some witness you don't know about, you're certainly entitled to call the new witness. Ms. Abramson says, but this isn't an area where an eyewitness or a percipient witness is stumbled upon. They made a tactical decision to go outside the coroner's office for a pathologist, and they could have done that 31 days before trial just as easily as the day before trial. The court says, I don't know that they could have found the witness 31 days before trial. Ms. Abramson says they started looking for him after we had the 801 hearing, after we had done the jury selection in this case. The court says that means they couldn't have found him before trial. Well, exactly, like why did they start looking so late? Emerson says they didn't look. They didn't look. The court says perhaps they didn't have the need to look. It would be arbitrary for me to rule that the defense is bound by its witness list and you cannot produce any new witnesses any more than the prosecution is bound by the witness list unless there is a finding by the court that there is deliberate withholding of witnesses to create a tactical advantage by one side or the other. If that occurs, then obviously the witness won't be permitted to testify. But I haven't been presented with that. All I have been presented with is they have found a new witness. Ms. Abramson says, I don't know that either, but our position is unless the court gives us sufficient time to talk to all the people we need to talk to, and that means we need a day or two out of this courtroom during the day to do that, that we are not going to be prepared to deal with Dr. Lawrence. That's the problem. The court says, well, it might be then you want to vacate the hearing on Eslamania and do it some other time and use tomorrow afternoon for that purpose. Ms. Nahara says that's fine. Mr. Khan says yes if we can proceed with Dr. Lawrence on Thursday. Let's see, do they? Oh, they do have, no, I don't see a Dr. Lawrence. There's a Lawrence Cohen who's a realtor, but there's no Dr. Lawrence. So, no, Dr. Lawrence does not testify this week. Even if I have 3 hours tomorrow afternoon to try and track down the coroner and my other experts, I have experts on this in 4 states. The court says tomorrow morning, tell me if you could make better use of tomorrow morning in preparation than you can in the hearing involving Eslamania, and if so, we can reschedule. Mr. Gessler says, I would state if in fact we can set up a conference call with Dr. Lawrence. Ms. Abramson says, I don't want a conference call. I want to talk to him myself. The court says, why don't you contact him tonight and see if you can reach him and see if maybe you can talk to him tomorrow afternoon. Ms. Abramson says, maybe Mr. Khan has a night number for him. Mr. Khan, if you can make a Mr. Khan says, if I can make a proposal. What we are willing to do, we were planning on bringing him in tomorrow so he can testify on Thursday. What we are willing for him to do is to have him meet with counsel after he meets with us tomorrow afternoon to give counsel an opportunity to speak with him if we can proceed on Thursday. Ms. Abramson says, I can't promise that, Mr. Khan. Mr. Khan says, this witness has rescheduled all of his patients, and he has frankly told me, my secretary, that he doesn't want to be a witness in this case if he can't get on this week. Well, frankly, Mr. Khan, that's your problem. That's not Mrs. Abramson's problem or the defendant's problem. Ms. Abramson says his patients are, wow. She says his patients are dead, Mr. Khan, because he's a pathologist, so his patients are he doesn't have to reschedule them. There's no real emergency because they're all dead. So the court says, I am not going to make any rulings that require witnesses to testify in a certain order just to accommodate a witness's schedule. If it's unfair to whichever side is being confronted with that witness, then I think it would be unfair to permit that witness to testify on Thursday without the defense having an opportunity to prepare for it. Mr. Khan says, okay. The court says, it's that simple. Ms. Abramson says, and just meeting with him is not enough. The court says, so if you guys can work out something that would make better use of tomorrow afternoon and reschedule the Eslamania hearing for some other time, I am willing to give you tomorrow afternoon. That's all I can say. Ms. Abramson says, I would certainly be happy to meet with Dr. Lawrence tomorrow afternoon. The court says, I don't know if he is coming in, if he is not testifying, and if you can do it by calling him, that's up to you. Mr. Khan says, we will find another pathologist. What? Now, Mr. Khan says, we will find another pathologist because you can't have him on Thursday, so now you're going to pout and be like, well, we'll find somebody else. Meh. I mean, what? And the court just ends it there. He's like, well, we'll be back tomorrow morning. That's enough of you. So, yeah, he just ends it. Interesting, huh? We are going to hop right into the next day, which is Monday, Tuesday, Wednesday. We're now on Wednesday. Valerie Hart, real estate agent. And we're just going to jump right into it. All right. Ms. Nahara asks, Ms. Hart, on October, so she's been sworn in and everything already. On October 15th, 1989, what were you working? Where were you working? I was working at the Marina City Club Towers. Could you tell the jury what exactly the Marina City Club Towers is? It's a 600-unit condominium complex in Marina del Rey. And Your Honor, I have a photograph which was previously marked as Exhibit 123, if I may. And showing you what has been previously marked as Exhibit 123, would you take a look at that and tell us what is depicted in that photograph? It's the 3 towers at Marina City Club. Okay, and this was where you were working? Yes. On October 15th, 1989? Yes, it was. And on October, what were your duties on October 15th, 1989 at the Marina City Towers? I represented the developer in the sales of the condominiums. And on October 15th, 1989, did some individuals come into your office who were present in court? Yes. Would that be the defendants who are present in court, Erik and Lyle Menendez? Yes. And when the defendants came into your office on October 15th, 1989, were they alone or were they with anybody? They were with another young man. And do you recall what his name was? No. And when the defendants walked into your office on October 15th, 1989, did you have a conversation with either or both of them? I spoke with Lyle and he spoke to me. And I said that they were and he said that they were interested in seeing the largest unit that they had available. And so that the record is clear, the person that you knew as Lyle, is that the individual sitting at the end of the table? Yes, it is. And when he said that well, that doesn't clear it up because is the person at the end of the table Lyle? Like they needed to clarify, like the person pointed to Lyle or whatever. And when he said that he would like to see the largest condominium that you have available, what would you say, if anything? What did you say? I took them up to the penthouse 29, which was the largest that we had available. And could you describe penthouse 29 for the jury? It's a 3,000 square foot, 2 stories, 2 bedrooms, and a den. Holy cow. And what was the price of that condominium? $990,000. And after you took the defendants up to this condominium, what happened then? I showed them around the condominium and explained a few of the amenities. Three of them, were talking amongst themselves, and I was up there for a while. I told them I had to go down to the office, that they could stay in the condominium as long as they wanted, and if they had any questions, I would be downstairs in the office. Okay, and at about what time of the day was this, if you recall? It was the early afternoon. And when you said you explained the amenities to them, what were the amenities of this condominium? Basically, the amenities of the complex itself, the tennis courts, and it had a health spa, swimming pools, restaurants. Your Honor, I have an exhibit which has been marked as number 124. And showing you, ma'am, what has been marked as Exhibit 124, would you take a look at the photograph and tell me if you recognize what's depicted in that photograph? Yes. These are 2 of the tennis courts and 2 of the paddle tennis courts at the Marina City Towers. Were these part of the amenities that you were explaining to the jury or to the defendants when they asked you about the condominium? Yes. Now, after you left the defendants up in the condominium to look around, what did you do? I went back to my office, and during that time, some of the other sales agents had mentioned that they had been up in objection, hearsay, Your Honor, says Mr. Levin. The court says sustained as to what anybody else said. Ms. Nahara says, did you stay in your office for a period of time? Yes. Did you talk to the other sales agents who had gone up to the condominium? Yes. And did you do anything with regards to that condominium at some point later on in time? I had gone back up with some other clients. Lyle and Erik were still in the condominium. They were sitting on the floor having a discussion. And how much time had passed from the time that you had left the defendants in the condominium to the time that you came back with the other prospective clients? Over 2 hours. Now you say when you came back, were all 3 of them sitting on the floor? Yes. And were they talking? Yes. And what happened after you came up to the condominium and you saw the 3 of them sitting on the floor talking? I was surprised they were still there, and I asked them if they had any questions, and Lyle asked me how long the office would be open. I said we would be there until 6. Now, after you told Lyle Menendez that you would be there until 6, what happened? I left. They were still there. And at some point later that day, did you see the defendants again? Yes. Shortly before the office closed, the 3 of them came down to the office. Noel left, and Erik and Lyle sat at my desk. Now, at that point, did you conduct any business with Erik and Lyle Menendez? Yes. And can you tell us exactly what was the first thing that happened? Lyle said that he was interested in the penthouse and they would like to write up a contract on it. And where was the defendant, Erik Menendez, when Lyle Menendez said this? He was sitting next to him. And what did you do when he told you this? I got the contract out and started filling it out. And did you fill out a contract? Yes, I did. And this contract, what was it exactly? A purchase agreement. And what is involved with this purchase agreement, this contract? It's the escrow instructions to purchase the condo. Ms. Nahara says, Your Honor, I have an exhibit which was previously been marked as 137. I would like it marked as 130 for this trial. The court agrees. Ms. Nahara continues, and I've shown it to the defense. And ma'am, showing you what has been marked Exhibit 130, would you look at that and tell me, take a moment, glance at the pages, and tell me if you recognize what it is? Yes, it's the new buyer information form, office form, and all the other documents that are required to purchase the condominium at the Marina City Towers. Now, Exhibit 130, is that the documentation that you were just testifying about? Yes. And how long does it take to fill out all of this documentation? Or how long did it take you to fill out all of this documentation? Probably about 45 minutes. And did you fill it out alone or did you fill it out with the defendants? I filled it out with the defendants. And on various places, did it have to be initialed and signed? Yes. Who initialed and signed it? Lyle Menendez. And where was the defendant, Erik Menendez, at this time? He was still sitting next to Lyle. And was the defendant, Erik Menendez, with Lyle Menendez the whole time that you were filling out? Yes, he was. This paperwork? Did you go through each page of this paperwork when you were filling it out with the defendant? Yes. Was there any kind of discussion about it? Towards the end, Lyle wanted to have some changes made to the condominium complex itself, and I made a list of the changes that he wanted made. And what were the changes that he wanted made? He wanted appliance. The court says, could you speak up a little bit, move a little closer to the mic? The witness says he wanted appliances included and a carpeting and wallpaper change and the parking changed. And did this involve more discussion on the contract and the paperwork that you were filling out? Yes. Now, at some point, did you complete all of the paperwork with the defendants? Yes. And what happened after you were through filling out the paperwork? That is Exhibit 138. 130. A deposit check was required, and Lyle asked Erik if he had a check. How much was required for the deposit? 3%, $29,700. Now, after it was, did you tell them that's how much you needed? Yes. When you told them that you needed a deposit check for $29,700, what, if anything, did the defendants do? Erik wrote a check for that amount of money. Did the defendant, Lyle Menendez, say anything? There was a discussion between Lyle and Erik as to whether there was enough money in the account to cover the check. Did the defendant, Lyle Menendez, ever take out any checks? No. Did he ever take out a checkbook? No. When you asked for the deposit, did the defendant, Erik Menendez, immediately take out his checkbook? Yes. And was a check written? Yes. And who wrote the check? Erik wrote the check. And did you take the check at that time? Yes, I did. And Your Honor, as a part of 130, and I'd like to mark it separately as 130A, separate and apart from the escrow documents, is what appears to be a Xerox of a check which counsel for the defense is aware of. Would you prefer 130A or 131? The court says it's just part of 130 as long as it's right there in the paperwork. Just leave it. Ms. Nahara says, okay, thank you, Your Honor. And showing you this part of Exhibit 130, ma'am, could you take a look at that and tell me if you recognize what that is? Yes, that's the check that was given to me on that day. Is that a Xerox copy of it? Yes, it is. And is this Xerox copy of the check that was written by the defendant, Erik Menendez? Yes. Was this a personal check, by the way? Yes. Now, after the check was written and given to you, what did you do with all this paperwork? Usually, we would report it as a, Mr. Levin says, objection with respect to the term usually. The court says, sustained, the answer is stricken. Ms. Nahara says, do you recall what you did next? I faxed the information to a loan officer and faxed the changes that Lyle had asked to be made to the developer. Now, at some point after this negotiation, did you see the defendants again? Yes. And when was that? The end of the week. They had come back with an attorney, and at that time, Lyle said that he wanted to cancel the contract because he had decided to rent 2 apartments instead of buying one. And did he tell you why he wanted to rent 2 apartments rather than buy? Objection calls for hearsay. Your Honor, it's irrelevant. Overruled. The witness says, he was planning on opening restaurants in New Jersey and he wouldn't be in town that often. Ms. Nahara says, and who was telling you this? Lyle. And after Lyle told you that he wanted to cancel this contract, what did you do? I returned the check. And when he came in to do this, was Lyle Menendez alone or was he with somebody? He was with an attorney. I believe his name was Stephen Goldberg. Was he with anyone else? And Erik. And this would be Erik Menendez. Yes. After Lyle Menendez canceled the contract, did they rent apartments at the Marina City Towers? Yes. By they, I'm referring to Erik and Lyle Menendez. Yes. And how many apartments did they rent? Mr. Levin says, excuse me, no personal knowledge. Ms. Nahara says, excuse me, condominiums. Sustained. Did you become aware of whether or not the defendants rented condominiums at the Marina City Towers? Yes. Did you become aware of how many they rented? Objection, it's hearsay by implication. The court says perhaps you can establish how she became aware of this. Ms. Nahara says, how did you become aware of this? Through the leasing office, and because I was, objection, Your Honor, it's hearsay from that point on. The court says, well, she hadn't finished her answer. I don't know if there was something else because of the leasing office and something else. The witness says, and they had owned condominiums, so I knew that they were renting in that complex. I saw them quite a bit on the property. Ms. Nahara says, did you see them coming and going? Yes. And were they renting 2 condominiums there? Objection, Your Honor, calls for speculation if they were renting from this witness. Court says sustained. Ms. Nahara says, how much does it cost to rent a condominium at the Marina City condo? Objection, irrelevant. Marina City Towers? Oh, she meant to say Marina City Towers. The court says, are you talking about a range of rent? Ms. Nahara says yes. The court says sustained. Objection sustained. The witness says 2-bedroom. The court says, wait, don't answer the question. Ms. Nahara says, is there a set price for a 1-bedroom, 2-bedroom, 3-bedroom condominium there? Yes. What was the set price for a 2-bedroom condo? Objection, irrelevant, sustained. It would be, okay, Your Honor, may I be heard in terms of foundation and give an offer of proof? The court says, well, if you can establish a foundation through this witness of something. Ms. Nahara says this would be foundational to another witness. Objection is sustained. And do you recall that you said that you saw the defendants coming and going from there while you were working there? Is that correct? Yes. And at some point, did you stop seeing them there? Yes. And are you aware that they got arrested in March of 1990? Yes. And at that time, did you stop seeing them at the Marina City Towers? Yes. Ms. Nahara says, thank you. I have nothing further. Cross-examination. So Mr. Levin is going to be doing the questioning. I switched him down on the screen so you can see his picture. Mr. Richard Gere / Barry Levin. At least he looks like Richard Gere from like Pretty Woman era to me in this photo, but that's the only photo that I can find of him. Anyways, Mr. Levin says, showing you what has just been marked as an exhibit. I think it was 130. What was that? Ms. Nahara says 130. 130. Is that the entire contract that was executed with respect to the transaction? Yes. And who is the buyer where it says new buyer information? Joseph Lyle Menendez. Does Erik Menendez's name appear anywhere on that page? No. The next page it says salesman. And is that your name, Valerie Hart? Yes. And it says buyer. Who is the buyer listed on that page? Joseph Lyle Menendez. Does Erik Menendez's name appear anywhere on that page? No. There's the next page. It says something homeowner signature. Whose signature appears on that page? Joseph Lyle Menendez. Does Erik Menendez's name appear anywhere on that page? No. There's another document here that says receipt for public report. Whose name appears on that page? Joseph Lyle Menendez. Does Erik Menendez's name appear anywhere? No. And likewise, if you went through this entire stack of documents, does Erik Menendez's name appear on any of the purchase contract pages? No, it does not. Does Erik Menendez's initial appear on any of the document that? No, it does not. Who was this contract with for the purchase of the condo? J.H. Snyder Company. Who was the buyer? Lyle Menendez. Was Erik Menendez a buyer? No. Was this a contract that in any way had any legal significance to Erik Menendez? Ms. Nahara says, objection calls for a conclusion from this witness with no foundation. The court says, that's also vague. What you mean? Mr. Levin says, you executed a contract for the purchase of a condominium solely with Lyle Menendez. Is that correct? Yes. And your state of mind was that in no way did the purchase of this condominium in any way bind Erik Menendez to do anything. Ms. Nahara says, objection as to her state of mind. It's irrelevant. Overruled. The witness says, I'm sorry. Could you, Mr. Levin says, Erik Menendez, as far as you were concerned, had nothing to do with the purchase of this condominium, correct? That's correct. Nor did the other individual with them. Isn't that correct? That's correct. Now, you also knew, did you not, that there was an individual who lived at the Marina City Club named Erica Facate? I don't know if that's how you say it. That's correct. And she had a son named Noel Nedley. Correct. And what Mrs. Facate told you, Ms. Nahara says, I'm going to object to anything that Ms. Facate might have said as hearsay. The court says, sounds like it would be. Mr. Levin says, it wasn't a surprise, was it, that Lyle Menendez had come to the Marina City Club to inquire about a condominium, correct? Ms. Nahara says, I'm going to object vague as to surprise. The court says, sustained. Mr. Levin says, am I correct in stating that you had prior knowledge that Lyle Menendez was going to come and inquire about a condominium at the Marina City Club? Objection, irrelevant, overruled. You may answer the question. Yes. So you had prior knowledge that he was coming. Mr. Levin says, and the individual that was with Lyle and Erik Menendez was Noel Nedley, the son of Erica Facate, who lived at the Marina City Club, correct? Yes. And you understood that Noel Nedley was a friend of Erik and Lyle Menendez, correct? Yes. I'm going to object no foundation. It would call for hearsay. The court says sustain, sustain. The answer is stricken. Now, Erica Facate lived at the Marina City Club at the time that Lyle and Erik Menendez came, or at the time that you saw them at the Marina City Club. Yes, she did. Objection, irrelevant, overruled. When you left them up in the penthouse and went back to the office, you don't know what they were doing for the period of time that they were out of your sight, do you? No. You don't know if they went downstairs and talked to Erica Facate or walked around the grounds to look at the tennis court area, do you? Ms. Nahara says, I'm going to object. No foundation. Assumes facts, not an evidence. Overruled. I know they were there the whole time. Mr. Levin says, you have personal knowledge from your own senses from seeing them there for a period of time that you left to the time that you came back that they were there? Only because I was told that they were there. Okay, but you can't talk about hearsay. I'm talking about personal knowledge. Do you have personal knowledge that they were there that entire time? No. And there's nothing wrong if they were there the entire time, is there? No. Was there anything that Lyle Menendez did with respect to the transaction that he tried to keep secret? No. Or confidential? No. Did he ask you anything to give you any information that caused you to believe that you were not supposed to report the fact that Lyle Menendez was interested in purchasing a condominium? No. Now, when Lyle Menendez came in, he did not ask to see the penthouse by using the word penthouse, did he? No. He merely said, I want to see the largest unit you have available, which happened to be the penthouse, correct? Yes. And how old are the marina or the condos at the Marina City Club? Oh, over 25 years old. So they are not by far the most exclusive or expensive condominiums in the marina area, are they? Yes. They are? At that time, they were. Yes. Okay. At that time in 1989? Yes. How many tennis courts are there? 6. And are there any indoor courts? Racquetball. Just racquetball courts. And there's also swimming and weightlifting? Yes. Now you had heard Lyle Menendez ask Erik Menendez for a check, correct? Yes. And you indicated before that when you were preparing this paperwork, that you went over the paperwork with the defendants. Is that your testimony? Yes. Are you saying that you went over each page with Noel Nedley? Noel was not present. So Noel left then, or when they came downstairs? Or she's saying Noel left when they came downstairs. So did you go over each page with Erik Menendez? They were both sitting in front of me, and as I explained each page, they were both there. Well, you were sitting at a desk, correct? Yes. And across from the desk was Lyle Menendez. Yes. And next to him was Erik Menendez. Yes. And you were executing a contract agreement with Lyle Menendez, not Erik, correct? Yes. And you were pointing things out in the contract to Lyle Menendez, correct? Yes. You would not point them out to a person who was not a buyer, would you? No. Now, included in this document is the word somewhere that says transaction not reported. Do you see that? Or did you see that? Yes. And this meeting that you had with Lyle Menendez occurred on a Sunday. Yes. And you would normally report the transaction to someone during the weekday? Yes. And I take it that you indicated that Lyle Menendez had requested some changes for which you did not have approval to accept at that time. Yes. So, is it not true then, when an individual requests certain changes in a contract, that the contract doesn't even become valid as an offer and acceptance of a contract until you can get an agreement to all the changes, sorry. That's correct. Ms. Nahara says, I'm going to object, calls for a legal conclusion. No, it doesn't. Overruled. So, it was your state of mind when Lyle Menendez left that you didn't even have an agreement with him at that time, correct? Correct. And you would not have had an agreement with him unless there would be further negotiations concerning the so-called changes that he wanted to add to the contract, correct? Correct. Now, you don't remember, do you, whether or not you were able to communicate back to Lyle Menendez the result of those changes? No. But you do know that who you communicated with did not agree to those changes that Lyle Menendez requested, correct? Correct. And I take it you were there when the attorney returned with Lyle Menendez. Yes. And this attorney, at least it was your state of mind that the attorney knew of the transaction that was occurring between you and Lyle Menendez? Yes. And at that time, the attorney indicated that the transaction was over, that there would be no completed contract. Well, Lyle was the one who said he wanted to cancel. And followed by the attorney saying that he was representing the estate and he was just there. But there was nothing to cancel, was there? Well, I had a check. You had a check, but you also had no agreement. At least it was your state of mind that you had no agreement. No. Between Lyle Menendez. It was a hold. So it was just a hold. So as far as dollars, how many dollars from Lyle Menendez was retained by your company? None. With respect to the demeanor of both Lyle and Erik Menendez, how would you describe first Erik Menendez? Objection irrelevant, overruled. Very serious. Mr. Levin says, have you described him before as quiet? Yes. And did he have his head down? Yes. They weren't having fun, were they? Objection, that calls for speculation. Sustained. If I might just have a moment, Your Honor. Was the penthouse available for rent? No. And do you remember the specific words that were spoken by Lyle Menendez when he asked Erik Menendez for a check? Do you have a check? That was it. The witness nods. And do you remember anything that Erik Menendez said? No, there was just the discussion of whether the money was available in the checking account or not. Oops. Mr. Levin says, okay, Thank you. Nothing further. The court says, Mr. Gessler. And he says, good morning. The witness says, good morning. This study club, had that been converted from apartments or was it built as condos? It was converted from apartments. When had it been built as an apartment building? In the 1970s. And do you know when the conversion took place to condos? 1987 or 88. So it had newly or within about a year converted to condos. Yes. Year and a half when Lyle and Erik Menendez approached you? Yes. May I approach, Your Honor? Certainly. This, the court says, 1:30. Okay, 1:30. This is the paperwork that you've been talking about, isn't it? Yes. And this is kind of the sheets that you were checking as you went through this transaction with Lyle Menendez? Yes. And does this contain the modifications that he asked you to see about in this purchase? Yes. Could you show us where that is? Have we found that now? Mm-hmm. And one of the things that he said was that he would like was a refrigerator, washer and dryer. Is that correct? Yes. And I take it that the person who had the authority said yes to that? Yes. And you've written yes on the transaction? Yes. So that means that it was approved, right? Yes. Now, the next one was he wanted to have or leave only a $10,000 deposit, isn't it? Yes. So you discussed with Lyle that it be a $10,000 deposit rather than 27 or 29.7. Yes, I must have. I don't actually remember this at the time. Is this your writing though? Want to leave only a $10,000 deposit? Yes, yes it is. And that's a writing that you made at the time that you were that you were talking with Lyle Menendez. Yes. About this unit. Yes. And I take it that you took that up with the owner too? Yes. And what'd he say? No. He didn't. And did you write no down on there? Yes, I did. So that is one of the modifications that Lyle Menendez asked that was declined, isn't it? Yes. And then he also wanted something about wallpaper changes and the flooring upgraded. Is that right? Yes. Did you write that down on the transaction here? Yes. Did you take that up with the owner? Yes, I did. What did he say? No. And you wrote that down here too? Yes. So those two modifications, at least that Lyle Menendez wanted, were actually refused by the owner of the property? Yes. Thank you. You've mentioned that you received or retained no money from Lyle Menendez regarding this transaction? That's correct. The check was returned? Yes. And you also retained no money from Erik Menendez concerning this transaction, did you? That's correct. It was a total wash. And then the leasing arrangements for an apartment or so was conducted, or a condo? That's correct. Thank you. I have nothing further. Court says any redirect. Ms. Nahara asks, now, when the defendants left your office on October 15th, 1989, you had a check for $29,700. Is that right? Yes. And is that before you right now? Yes. And did or does Lyle Menendez appear anywhere on that check? No. And is he, when you look at the face of that check, any way legally responsible for that check? No. Mr. Levin says, objection, withdraw. Ms. Nahara says, and you were asked how many dollars were retained by the defendant, Lyle Menendez, and you said none. Is that correct? That's correct. And in fact, you never had any money from the defendant, Lyle Menendez. Is that correct? That's correct. And I believe you stated that the defendant, Erik Menendez, was very serious at the time. Is that right? Yes. Were both defendants very serious about this? Yes. And when they were up there for quite some time in terms of looking at the condominium. Is that right? Yes. Is purchasing a condominium a serious matter? Yes. Nothing further. Anything else? A little bit of recross here by Mr. Levin. He asks, "What were you authorized to do with that check?" "I was going to hold it until we can see if these other matters were going to be changed." "So you weren't authorized to deposit that check, were you?" "No." "The check was being held, correct?" "Yes." "Could you flip to the check for a second?" "The check is it was drawn on a bank. Where?" "Princeton, New Jersey." "And the name Erik Menendez appears on the check?" "Yes." "What's the date that he wrote on the check?" "September 15th, 1989. What was the date that he wrote the check?" So he wrote on the check September 15th, but the date that he actually wrote the check was October 15th, 1989. So he wrote the wrong date on the check. Yes, he did. Did you notice that when he wrote it? I didn't notice it that day. No. You did not, or you did. Not when I accepted the check. I didn't notice it. Mr. Levin says, "Thank you, nothing further." Ms. Nahara says, "One question. Just so this was clear, there was no agreement to post-date the check. Is that correct?" "No." So I've recrossed very briefly. Mr. Levin asks, "That check is not post-dated, is it? It's pre-dated." "Yes." Ms. Nahara says, "Or predated, I should say." The court says, "Okay, thank you. You may step down. You're excused." Your next witness, and we will save this for Thursday. We've got Donovan Goodrow, who, as we know, was friends with Lyle and Erik. Eventually, there was a falling out between Lyle and Donovan, and somehow Lyle had his ID, and then that was used by Erik for a fake ID for also purchasing the shotgun. So we will learn more about that and the falling out between between Lyle and Donovan Goodrow when we return on Thursday. So thank you guys, or sorry, this should be Friday. Friday, we've moved to Fridays. Um, Thank you guys so much for watching. Let me know what you think, and I will see you guys in the next one. Take care. Bye now.